So let's talk about what is a good durable power of attorney. That would be one where you've named first one person, then you've named another person, and then you've named another person. We really like to see 3 successive designations for who will be your agent, your power of attorney under your document. You don't have to do that, but I can tell you if you only name one, what's going to happen to your power of attorney, the effectiveness of it, if that person you've named is not capable. Or if you name joint co-powers of attorney, 2 people to be making decisions, that also can be problematic. Oftentimes if they're joint and they have to agree, what happens if they don't agree? It ends up in court. Or if you name 2 people and they're independently authorized to make decisions, what happens if they don't communicate? Well, it becomes a mess. So our recommendation typically, not always, but typically is you name one person and then another and then another. Do you need a power of attorney if you're married? Yeah, you do. Why? Because you are your own person and your spouse is their own person. And just because you're married doesn't give you any legal authority to manage their affairs. And couples get really confused when I make this statement. How could that be? I mean, you both can write checks off of the same account, right? You can, I'm showing my age by saying writing checks, but you both can transact under your bank account, right? Well, yes, if it's a joint account, but what if it's only in your name? You don't have any legal authority to manage your spouse's bank account. You can't sell your house without your spouse also signing off on the sale of the house. Even if both your names are there, you can't do it. You need legal authority to do so. So spouses, you both need durable powers of attorney. And when it comes to, well, how good does this legal document need to be? In my opinion, it is critically important that it be a very good document, not some form and not something that was just given to you by an attorney that says, hey, I can do your will, I can do your powers of attorney. And they also can do a bunch of other things for you because they're a generalist. I really recommend that you see an elder law attorney, and this is why. An elder law attorney understands government benefits. We understand what it takes in a power of attorney to have sufficient authority to do planning that's going to save you money, especially in the face of long-term care costs. As people age, long-term care goes from being a possibility to a probability. Long-term care is very expensive. $5,000 a month, $10,000 a month, $15,000 a month. What that means is the money goes very quickly. An elder law attorney should put into your durable power of attorney for finances the necessary authority that's needed such that if you lose capacity or your spouse loses capacity, that we can, as an elder law attorney, help you protect assets while at the same time qualifying for Medicaid long-term care benefits. Medicare doesn't pay for long-term care. Medicaid does. And we'll talk about, I'll give you some examples of how you can protect assets against Medicaid and long-term care costs. It's important that you have robust powers of attorney, especially when it comes to financial matters.